Let me welcome you all this late afternoon here in Germany and in Europe, and midday, mid-morning in the US, to this event in the Max Planck Law Forward series. For the benefit of our presenters today, I'll say just a couple of words about Max Planck Law so that they know what they've gotten themselves into, what kind of crowd they're dealing with. And then I'll make an introduction of them to all of you. Max Planck Law is a consortium of the 10 Max Planck institutes in Germany and Luxembourg that are focused on legal research, unlike our sister and brother institutes that focus on the natural sciences, physics and chemistry. Max Planck also does incredible foundational research in nearly every subdiscipline of the law across these 10 institutes. They feature the work of 20 world-class directors and nearly 400 PhD and postdoc researchers. We're thrilled to be able to serve them at Max Planck Law as a mechanism for promoting cooperation and collaboration across these institutes. And on one hand, but on the other hand, actually provide this service of, in this case, some professional development support to the researchers across the network. And that professional development support, as I mentioned to our guests, has been aided significantly by Clara Rigoni and Annika Zeman, respectively based in Freiburg and in Munich. So I'm glad to have them join me here very much so, because it gives me a chance to thank them for all their cooperation and support. Our offer of support services to the researchers in the network at Max Planck Law has three aims. One is to give some support and direction to the researchers' job-seeking interests. And that you can see how this panel fits into that agenda, but also with respect to publication strategies. In that sense, we earlier hosted sessions on the US law review publication market, for example, another, how could we say it, quirky comparative discussion. And we've also had a discussion on publication in the UK law academic market. We also will begin soon to coordinate and promote those portions of the Planck Academy system, which more generally serves the interests of researchers across the Max Planck Society in natural sciences and humanities and social sciences, where their offerings may be of particular interest to legal researchers like those in this network. So today's program fits into the work we're doing to provide support to our researchers relative to job-seeking strategies. And we've taken up today's discussion because Clara and Annika and we conducted a survey of the researchers, and both job-seeking and job-seeking support with respect to academic positions outside of Germany were a priority. And we were able to get a bit of granular feedback and identify a few of the markets outside of the German market that were interesting to the researchers in the network. And the United States was one of them. So that's what motivated us to bring in today our guides to one of the world's biggest, most diverse and distinct, let's call it that, markets for the legal academic work, including research and teaching in the United States. We're really lucky to have Professor Antonia Eliason join us from the University of Mississippi School of Law, where she's currently co-chairing the law school's hiring committee, and reported that later today they'll be welcoming back a callback candidate. So she's really in the thick of this discussion and these interests. We're also lucky to have Antonia with us because she has extensive overseas and international law experience, and that will allow her to reflect on and tailor her remarks about the US market to the interests of the researchers in the Max Planck Law Network who are foreign trained. She practiced law in London and in Hong Kong, and participated in internships at the World Trade Organization, as well as at the Court of Justice for the European Union. Her research and teaching focus on contracts, international trade law, international investment and finance, EU law, and after the call, let's talk about this interest in law and science fiction. That's the real winner for me in that list. So it's great to have you with us today. She's accompanied by Professor Brannon Denning, who is the Starnes Professor of Law at the Cumberland Law School at Samford University in Birmingham, Alabama. And we're really lucky to have him with us today. He's one of the co-authors of the American Bar Association commissioned book entitled, fittingly for our discussion today, Becoming a Law Professor, a Candidate's Guide. So we're lucky to have that background, research interest, and expertise around this question. Brannon's work at the Cumberland Law School involves teaching and research focused on constitutional law. That involves Commerce Clause questions under the US Constitution, as well as Second Amendment questions. So both profound and impressive scholars who today we're drawing into a conversation about these practical and professional issues with respect to hiring in the US law school market. So with that, I thought we would bring Brannon into the conversation first to talk a bit about some of the formalities and more general issues related to this question. And then we'll move over to Antonia and hear some reflections on the current market and the current landscape. Thank you both so much.
Great, thank you, Russell, and guten Tag.
Well said.
I'm pleased to be here with Antonia and Russell, and hope to be able to provide you all with some useful information. I thought what I would do is just sort of give you a kind of thumbnail overview of what the U.S. Legal Academy looks like, and then talk a little bit about the historic process. And I've emphasized the word historic process for hiring, because as Antonia will tell you, this is as a result of COVID and some other forces, is apparently undergoing some pretty significant changes. I think that, and maybe it'd be worth having a discussion about which of the changes are likely to be lasting and which might be transitory. So there are 199 American Bar Association accredited law schools in the United States. And ABA accreditation is important because if you are going to apply for passing the bar exam in any state in the country, you really need to have graduated from an ABA accredited law school, as opposed to an unaccredited law school, which usually restricts you to the state in which that law school is located. The ABA requires, as part of its accreditation, that faculty be full-time faculty members, that they not have a sort of a side practice, and that there be some form of tenure protection. And the law school job in the United States traditionally is seen as having three components: teaching, scholarship, and then service on committees and otherwise. And these are sort of the three legs of the stool, if you will. Teaching at many places is no more than 4 courses a year, 2 courses each semester. At some larger schools with larger faculties, and those schools that emphasize scholarship a great deal, you may have a 3-course load, or sometimes even a 2-course load. Entering salaries are fairly high, especially relative to other academic positions, though I think everybody would agree that they plateau pretty quickly. And you will find that your acquaintances who stay in practice will end up being able to buy and sell you at some point if they stay in the practice. excuse me. Traditionally, entry-level hiring was centralized. The Association of American Law Schools, which is an agency that it doesn't really accredit law schools, but it has member schools. It had sort of commanded the role in hiring. And I'll describe that a little more in a minute. And also legal academia has tended to be competitive. I went on the market in 1998, and there were roughly 10 applicants for every open position. And I think that has, I looked at the numbers today, and the number of applicants in the first distribution, I'll explain what that means in a minute, is about half what it was 10 years ago. So I think that there are fewer people who are seeking jobs in the academy, probably owing to the fact that people have been told for so many years about how difficult and how competitive the market is. The irony is now it's becoming a little more of a seller's market, I think, particularly this year. So who are successful applicants? In the book, I sort of, in the goal is divided into three parts kind of spirit. We came up with three types of candidates. One that we call the standard model candidate, a second we called the revised standard model candidate, and then third, the non-standard model candidate. So the standard model candidate is maybe what you would expect. You graduate from one of the 12 to 14 top 10 law schools in the United States. You get a prestigious clerkship, preferably on one of the federal appellate courts. And if you're truly a superstar with the US Supreme Court, practice for a time, a couple of years, not too long, with an elite law firm. And you may or may not have done extensive writing. Although one thing that I would note about standard model candidates that have changed over the last 10 years since the book was first published is that many of these, even those who went to elite law schools, will also usually have a visiting assistant professorship or some kind of fellowship at a place like Harvard or the University of Chicago before they go on the market. And that is a change, I think, even within the last 10 to 15 years. Well, what about the revised standard model candidate? This is someone who graduated from a non-elite law school, but then, sort of laundered their non-elite law degree through an elite LLM or a fellowship or visiting assistant professorship, or both, at an elite law school. These revised standard model candidates tend to have done a lot more pre-interview or entering the market publication, because frankly, that's about the only thing that you can control. You can't, redo law school, but as you're readying yourself as a candidate, you can write a great deal. And if you get good placements, it shows that you're the kind of person who will keep writing if you've done a lot of writing when you didn't have to, when nobody was making you, and when you were not under the tenure gun. What about non-standard model candidates? These are less common. It would be a non-elite graduate, somebody who did not necessarily, for whatever reason, get an LLM, but has done extensive writing. This includes sometimes legal writing and clinic professors who wish to transition to full-time teaching, and sometimes long-time practitioners, people who have practiced for over a decade or more, and at a sort of an older age seek to join a faculty. Well, what has changed? Let me talk for a second about what has changed in the legal academy. I think one of the biggest changes in the last 40 to 50 years is the fact that even at lower ranked places like Cumberland, all the professors are expected to write. Legal academia has become as much a writing job as a teaching job. Second thing I think that's changed is the proliferation of visiting assistant professorships and fellowships. And I would say the last time that we went to the hiring conference in Washington, D.C., I think nearly every person with whom we had a screening interview had done one or the other, or both. The other thing that's changed is the importance of and the expectation that candidates will have done a significant amount of writing prior to going on the market. When I went on the market in the late 90s, I was unusual because I had published, I think I had 5 or so publications going into it. And that was really unusual because many people at that time who were being interviewed might not have written anything other than what they had published as a student. And then finally, I think one of the other things in terms of getting your writing distributed is that the rise of SSRN, the Social Science Research Network, has really, not completely, but it's disintermediated journals somewhat. It's a way that you can get your scholarship out there and circulate it among people in your community without having to go through the journals first, or at least it's another path. So let me spend a couple of minutes describing the historic hiring process that is undergoing apparently some change, and the change might end up being quite significant. So in the olden days, what you did is when you decided you wanted to go on the market, you would fill out a form called that would go in a binder with a lot of other forms that looked exactly the same. And this would be done usually about August. And these forms would list, who you are, where you are, education, teaching preferences, publications, etc. And they would go out to the law schools in 3 different distributions. I think September, October, November, I think they would go out. And of course, all the real serious candidates were in the first distribution. These would be distributed to the law schools that were hiring. Committees would go through these and decide who they wanted to have screening interviews with. Screening interviews were just 30 minutes. It's almost like speed dating. And that would occur at the faculty recruiting conference in Washington, D.C., at the Warman Park Marriott. And I say that only because anybody who's been through the process is intimately familiar with the layout of the hotel, which unfortunately they're tearing down. So this conference would occur in sometime in October. Sometime it had been as late as early November, but usually it would be some early mid-October. It would be over a Thursday, Friday, Saturday. You would interview with all the schools that were interested in you, that you were interested in. And then the committees would get together and, depending on how many positions they were filling that year, would decide who they would call back to the school. So the callback was a visit that would be paid for by the law school. You would fly to the city where the law school was located. You would have a day-long or 2 days long series of interviews with the entire faculty. And then you would give a job talk. Usually it would be scheduled for lunch. And you would present either something that you had published or something that you were working on. And that was sort of it did a couple of things. It allowed people to, assess your scholarship. And then it also, at least for us, tended to function as a kind of proxy for what kind of presence you might be in the classroom. Interestingly enough, until very recently, almost no one attempted to check whether you might be any good in the classroom as a teacher beyond that, although I think law schools have gotten a little more interested in asking questions about pedagogical approach, et cetera. And then after the callbacks, depending on how many they were, the committees would meet, make recommendations, usually to the dean, sometimes to the university provost, sometimes they would rank, sometimes not. And then once an offer was made, there would be a little bit of negotiation between the candidate and the dean over things like whether you received a lighter load your first semester, maybe what kind of research support that you got in terms of a summer stipend, and maybe some negotiation over salary, but usually those are pretty locked in and limited by the university. So that's been the historic process. Yeah. And I think now with that, maybe Antonia can tell you a little bit about how that process is undergoing some change. And I look forward to answering any questions I can when we finish.
All right, well, thank you for that. A lot of what you just said is obviously still very much the way things are, including the callback format. But this year, all the rules are out the window and things are different, right? So last year they had to cancel the AALS hiring convention because you obviously can't have a bunch of people in a hotel. Terrible idea. This year, obviously, we're still not going to do this. So we still have these FAR distributions that come out end of August, and then there was, or first week of September, and then there was one that the second one just came out. And I've got a couple numbers on this. So as Brannon mentioned, the numbers are way down. So in 2009, there were 637 people in the first FAR distribution. There were 328 this first FAR distribution. The second FAR distribution had 38 people in it. That's it. So huge change. And I was hired in 2013, which was kind of the last boom year for hiring, where like lots of law schools were hiring lots of people. And then after that, my colleague and I were hired as part of a double hire entry level. And then we hired no tenure track people until we had somebody irreplaceable leave. And 2 years ago, we hired one person. So you can imagine like this whole window, nobody's getting hired. And I think that's why a lot of people just stopped even bother applying for academic jobs. Q this year, and for a combination of factors, it seems like every law school is hiring in the US. Part of that is because nobody hired for that many years and people retire. And we had, so when I was hired, we were dealing with the fallout of the 2008 financial crisis, which meant that we had record low levels of applicants to law schools. So we were concerned at Mississippi, could we even get 100 students in a class? This past year, we were up to 200. Luckily, a few decided to not come to law school. So we're at like 184 or something, which think about 2013, we were barely scraping 100. We're almost double. There, if you look it up, there are reports of law schools around the states that have had to defer law students until next year. So I think Boston University or Boston College, one of them did that. Berkeley did that. I think this is a combination of what I call the Trump effect. A lot of people, particularly progressives, found that our judicial institutions were quite weak. And in the wake of Trump being elected, I think that drove a number of progressives to fight through the judicial system and to go to law school. On the other side, I think it also put some conservatives into law school as well, who saw the possibility for sort of affecting the shape of American politics through the American judiciary. So we're seeing this big surge in numbers. And I think the other thing is every time you have kind of a financial boom, when there's a little bit of a downturn, but it hasn't quite crashed, people go to grad school because they're not sure what to do. So right now, we have a very large group of students who are applying to law school. And we have a ton of people who retired, both over the past sort of 8-9 years, but a big burst of people retired because of COVID. So a lot of older faculty who didn't want to navigate the world of Zoom and of, sort of the new technology that teaching virtually brought, took this opportunity to say, you know what, peace out. I've been here forever. I'm going to go do something else. I have a colleague who's now happily woodworking, and I think is much happier doing that. And you avoid the burnout. But that means that now we have a ton of schools hiring for tenure track positions to fill all of this period of positions that have been lost. And so speaking from anecdotally from our experience, traditionally appointments committees or hiring committees would be established sometime in August, right at the beginning of the semester. Our dean set us up in May. We have been meeting consistently since June. We started identifying candidates in July, and we did screening interviews already at the beginning of August. We've been doing callbacks since the beginning of September, and we have a chunk of callbacks that will be done by next week. We're going to have a faculty vote on those candidates that we've seen, and then visit the next batch to bring more people back if we need to. So we're doing things on a rolling basis. That is not at all how things used to work, right? It used to be that you would wait until you saw every single person and the job offers would be made in December. Whole different ballpark. I mean, it is possible that next week, Wednesday, our faculty will make job offers. I have also heard from candidates that we did screening interviews on that they've also been getting offers from other schools. And there are still some law schools who didn't quite realize this was happening and just set up their appointments committees. And so they're a little bit behind the curve. This is a bit of a seller's market. I have heard anecdotally, though, that a lot of schools are also looking for laterals. So for people with experience to move because there's sort of a dearth of entry-level candidates. The other thing is I have heard from candidates that there is a downside, right? It sounds like, oh, this is amazing. Everyone's hiring. What a fantastic chance for candidates. But it's creating chaos for candidates because traditionally you could rely on this timeline that you would kind of get all of your offers at the same time. And so you could say, all right, this is the best school that I got a job offer from, I'm going there. Now that doesn't work because you can't hold out and hedge your bet. If you get a job offer, how much can you navigate it? They're usually time barred for a few weeks. So everything is very appended for candidates as much as it is for hiring committees. So it really is happening on both ends. So this is really changing how things are. And I think the traditional hiring conference in person, I'm not sure that's going to come back. And I think for two reasons. One, screening interviews are a lot easier and cheaper for everyone when you can do them over Zoom. And for candidates, it also offers candidates who might not have the money to fly to DC and get a hotel room. I mean, when I interviewed, I was working in London. I was working for a big law firm, so I had cash to burn. So I flew to DC for a couple of days to do the interview. But if you're a European candidate or a candidate outside of the US, obviously that's not particularly financially feasible for most people. And for a lot of candidates in the United States as well, like people don't have money to go to DC and get a hotel room. So there's an equity level to this that I think that we're seeing. We're trying to be more equitable and diverse in the hiring process. And for that reason, I think as well, that old model may be done. The FAR, I think, is going to continue. People can submit their resumes. It's nice to have them in one place. For a hiring committee, you can search by keywords. If you're looking to hire something specific, you can narrow it and just see all the candidates that do tax law, for instance. Great for a hiring committee. But we also actively identified candidates outside of the FAR. So, we are interested in hiring diverse candidates. We're interested in a whole range of different candidates. We reached out through different listservs to get access to candidates. And then, of course, there's the very organized top-tier law schools, particularly the Yales and the NYUs, who send you their books of candidates with all their resumes and information, either electronically or physically. But we've been trying to not keep ourselves focused just on people with this traditional elite credentials, because that also limits elite comes in quotes, right? This kind of limits who you end up having as candidates. And we're really trying to look outside the box. So things that we care about, and I want to talk a little bit about this. What are law schools looking for? Well, it depends a lot on the law school. If you're a top 14 American law school, you're looking for something very different than if you're the rest of American law schools. In terms of teaching candidates, you are looking for people that are in the top sort of 14, top 25 law schools. You're more focused on academic pedigree, on those fancy clerkships. Maybe you're more interested in theoretical work by candidates or kind of superstar candidates in some sense or the other. But that's not the majority of this 199 law schools in the United States. So from our perspective, we care a lot about having practice experience. We don't want people who are fresh out of law school. We want people who ideally have worked in the field that they're planning to teach in for a few years. That's something we really value. And we have at Mississippi, because we've always been a very student-centric, sort of pedagogy-centric, trying to prepare our law students for legal practice kind of law school. We're seeing this shift across the American Legal Academy because the American Bar Association has also shifted the requirements of American law schools to be more practice focused. So there's more of a focus on formative assessments. On the traditional American legal model was you do a semester of classes, you have a final exam at the end, and voila, you're done. We're trying to do more assessments in the middle, and this is something that the American Bar Association and the American Association of Law Schools really care about. Give the students more hands-on exercises in the disciplines that they are studying. Part of this is also coming from law schools or from employers who expect practice-ready lawyers coming out of law schools. And I have a lot to say about how that's a terrible idea, but I won't say it. But basically, it's really not the room of law schools to produce practice-ready professionals, because as anyone who's practiced knows, you don't learn what the practice is until you are in the actual practice of it, and every firm in every area does something different. Never mind. So we are a professional school, right? Unlike in most of the world where law school is an undergraduate degree, where you go from high school to law school and you are still a baby human being. We are looking at people who finished 4 years of university and have gone to become lawyers. So because we're a professional school, there's also a technical component to what we do that I think pedagogically is much more focused on in the United States than in Europe. When I think about law in Europe, it's much more theoretical, the approaches to law. There's a lot more in the scholarship and in the sort of thought process that's based on theory. In American law schools, other than sort of the top 14 law schools, theory is not a critical focus. Now, we love to have someone who can teach one theory class out of a package of 4 classes, right? 3 substantive classes and 1 theory class. But you're not going to find a whole lot of legal theory, legal philosophy folks the way you do in Europe. It's just a really different model of legal education and of legal practice. So I think we're moving away from some of what we had seen before to even more kind of practice experience. And the way we've done for us is this rolling basis of evaluating candidates. We have had screening interviews with incredible candidates. And honestly, out of the people we've screened, a majority of them we would be happy to have as colleagues. So you have to narrow it down because you're going to bring some people back in person. What we have done is offer the option, because it's COVID, of having either virtual callbacks or in-person callbacks, because some people are not comfortable due to COVID being in person. I think that's not going to continue. I think once COVID is more or less over or stabilized, it will all be back to in-person callbacks, because you lose a lot in the virtual environment on Zoom for a full day callback. But we have prioritized candidates in areas that we essentially have to hire someone. So for instance, we are desperate. We need a tax person. We need a bankruptcy person. We have decided that that's like our first priorities, because we're hiring 3 to 4 people, which is a huge amount, especially not having hired anyone for years. So you're really focusing on what is needed. And so we had a very generalized job advertisement because some of the positions are very open, but we listed some of the core areas we were looking for. Definitely reading the job advertisements and making it clear. That is a really key component to applying to the correct schools. Now, one thing about the FAR, which I think it's important to bring up. So my husband's English, and he thinks this is, pardon my French, the most ass-backwards system he has ever heard of in terms of hiring. So he used to work in recruitment. You're basically, as a law professor, getting hundreds of candidates that then you effectively become your own hiring manager and your own headhunter, and you go through these resumes and reach out to the candidates to invite them for interviews. Right, I'm not an expert in any of this. I'm a law professor, not somebody who hires people for a living. In contrast, the way we have done elsewhere and what we did earlier is we have the job posted to our website. We disseminated it through lots of blogs and Twitter and other channels, and people have directly applied. And then we review those. So one of the odd things is when you reach out to candidates that you are interested in, well, obviously they might not be interested in you at all, right? Like we had some candidates say thank you, but no thank you. Basically, they don't want to be in Mississippi or whatever reason. So that is a weird feature of that. And knowing if you're on the job market, you can geographically restrict yourself. I will say when I'm looking at resumes, if somebody's too geographically restricted, it makes me question something about their desire to be a law professor. But if you're, if somebody extends an invitation for a callback and you don't want to go there, then there's no point in taking it. I mean, the screening interviews are 30 minutes, but I suppose it can be good practice for you, but we can kind of tell if you're not really interested in being with us. So for a school like us, and I think when I say like us, I mean anyone who's not in a big major American urban market. So not Boston, not New York, not, San Francisco, not Chicago, not somewhere that I think is highly desirable geographically. We also want to hear why you're interested in teaching at our school. And that doesn't mean that you have to say, my whole life I dreamt of going to Mississippi, right? Like that we can tell when people are lying, don't need that either. But what you want is you want to kind of tell people that, hey, either I love new experiences. I had no ties to the South. I said I really wanted to live somewhere that was unlike anywhere else I'd ever lived, and Mississippi fit that bill. And it, I was fascinated by the culture and the history. We find that, for some people, the social justice work that you can do in Mississippi as a state that's fraught with a lot of racial tension and issues that we're still working through, that's an interesting hook for some people. But whatever school you interview at, nobody's going to ask you that in New York. Why do you want to be in New York, right? We all know why you want to be in New York. But especially when you're not coming from the US, why do you really, would you really move to a state like Nebraska, Mississippi, Idaho? And so you have to think about being able to respond to that question. And again, you don't have to lie and sell fairy tales of like, you've always dreamt of living in Idaho, because let's be honest, nobody has. But you need to have some kind of response that's thoughtful and recognizes that it is a real question for those of us on the hiring committee, particularly when we are bringing people back for callbacks, because callbacks are costly. And we don't want to bring somebody back who, yeah, they might be fantastic on paper, but they have no interest in being here. And then we don't think they would accept a job. And that has actually been something that we have considered in deciding who to extend callbacks to. Like, would they genuinely want to come here? Or are we wasting our money by sending them here? Are they just going to use us to leverage another job opportunity? So you kind of have to sell yourself in that sense to schools in perhaps less desirable geographic locations. The other thing that's important is obviously, and we talked a bit about this already, are some of the things that I like to call these that, and I'm speaking again as from an American law school that's in the middle of the pack, which, let's be honest, that's what most of the law schools are, right? Like your Ivy Leagues are a very small number. The top 14s are a very small number. The chances of getting a job there are understandably relatively low. And what they are looking for, especially for non-American candidates, is entirely different. So a lot of this advice doesn't go for top 14 schools because they are really interested in the research and scholarship more than these three things. So my 3 points, my 3 Ps of American hiring. First of all, publications, right? We've talked about this. You have to have it. Traditionally, it was at least one significant publication. Now the numbers of publications people are coming in with seems to be growing. The other thing is we do notice if it's just like a chapter of a PhD dissertation, we want to see something that's, because there are more and more candidates with PhDs, even PhDs from the United States. That was not the case even 10 years ago. Everyone now, like I see so many PhDs in the applications. So we don't just want to see your PhD thesis recycled. We want to see, that's fine if there's a piece of that, but we also want to see maybe another article that's different from your PhD research to show this sort of capability of a larger research agenda. And we're always interested in, you know, whether you have a research agenda, what you're looking to publish in the next upcoming 5 years, you know, whether it's concretely articulated or broader. In terms of where it's published, I think even for middle of the road schools like us, we recognize highly rated European peer-reviewed journals. I mean, this is something that, you know, nobody's going to sneeze at, you know, Journal of World Trade or, you know, Journal of International Economic Law or something like that, right? Like we recognize those. But law review publications and American law journals, whether it's the international, like I mostly publish in the international journals of various law schools. So like I have a forthcoming one in Pennsylvania Journal of International Law. Like I tend to focus a lot on international law journals. Those are fine too. They don't have to be law reviews. But obviously, if you're writing in general topics, and we'll get to this in a second, you're going to want to try to place in a law review. And that whole game, I mean, it sounds, Russell, like y'all have done some discussion of the publishing stuff. That's a whole different topic to sort of talk about. So that's the first P, publications. The second P is practice, right? As I said, work experience really matters. And what your work experience is going to depend on the area, and I'll talk more about that in a second. And then the third P is pedagogy. And that's something we are caring more and more about because, you know, especially a student-centered law school, which all law schools should be student-centered, but we all know that some of them care less about their students than others and more about their research. But pedagogically, how would you teach? And one of the things we're looking for is more than just the traditional Socratic method. So saying that you're going to go into a room and cold call people and grill them until they cry is not going to get you a lot of points in the hiring committee, even though a lot of us, that's the way we experience law school. We're looking for this balance, sort of an adjusted Socratic method, ideas of sort of formative assessments, working through things. We're looking for something innovative as well. So we're looking for pedagogical changes, for things that still maintain the rigor of traditional legal education, but maybe take out some of the gatekeeping that tended to favor rich white men and honestly left a lot of people at the margins. And I think we're looking for people who understand that. So that's the 3 Ps. There are other components. So service is one of the big things you do in legal academia. But we realize asking questions about service to entry-level candidates, like what committee would you like to serve on? I don't know, I haven't been at a law school on a committee, right? They're not super good questions to ask people. But at least thinking about how you would engage with the broader faculty or maybe the broader university, if you have interests that go beyond just one department, that's stuff that's candy to a hiring committee. There's also increasingly, and American law schools are really focused on this. At the University of Mississippi, we adopted unanimously a strategic plan for diversity, equity, and inclusion last year. We are taking that very seriously. And I think you're going to see a lot of law schools, whether or not they take it seriously, will ask you questions about diversity, equity, and inclusion, and how you've thought about that pedagogically and in your research. And I think that's something that American candidates kind of know they're getting this question because it's discussed so often. And I think that might be for a non-American candidate something you're less likely to expect, simply because it doesn't get talked about as much in Europe in the same context. So understanding, you know, how do we work on improving diversity? How do we work on improving equity? How do we, you know, do this in a student body? How do we recognize that there's more to jurisprudence than just old white men? Like that's a really important component, I think, to what we're doing. So another really important thing is your primary areas of curricular interest. So for us, we've had many excellent candidates who we have decided not to move forward even to screening interviews because what they wanted to teach or what their specialties were just something we don't need, right? We have a fairly strong criminal law program, don't need another criminal law person right now, right? Like we're really thin in some areas and we don't have a lot of lines, so we're focusing on things to fill holes that we don't have. So making sure that you align with what the job advertisement says and put together a package of classes. And this also goes back to Brennan's point that when you have Most schools is a 2-2, so 2 classes per semester that you teach. One of the things we want to hear is, what would your ideal teaching package look like? So put together the 4 classes you would like to teach. A lot of American law schools want someone who can teach at least one first-year doctrinal law class as part of that package. And that can be a challenge, I think, for non-American folks going into the job market, because obviously, unless you've done an LLM in the States or taken civil procedure in the States, right, you're not really going to be teaching civil procedure or criminal law to an American like that. We wouldn't think that that would be a great fit. So thinking about what you can teach, and one of the questions we've been asking our candidates is, on top of the stuff that's sort of foundational, if you could teach a class that just made you excited and happy, even if it's outside of what you've listed as curricular interests, tell us about it, because we're also looking for curricular innovation. So if there's a really cool seminar idea that you have, like, people want to hear that. And I know that, like, some schools, for instance, here we're giving, I got a summer course development grant to develop a new course because they're working on trying to create more interesting classes. And I've designed a course that I'll be teaching next year on climate justice that looks at international and domestic issues, particularly sort of linking some grassroots Mississippi organizations with what happens kind of in the global community on climate justice. And these sorts of ideas of seminars, whether it's a theoretical one, whether it's, feminist jurisprudence, or, if you have a specific interest, I don't know, bankruptcy of cities. A lot of law schools are moving to teaching 1-credit classes as sort of these mini cool classes that people can take, 1 or 2 credits that are seminars that only might meet once a week. And that's where you get to kind of have really interesting courses. I mean, we had a bankruptcy professor who taught like municipal bankruptcy, focusing only on the city of Detroit. And that was a really fascinating class. So things like that can also be helpful in showing the range of what you're interested in. The reality is that in terms of areas, business law and finance, those are areas where you have a decent shot as a non-American candidate. I mean, those are some of the stronger areas because they translate well. You can teach American corporations if you've done any kind of corporations work, because even if you have to learn it a little bit from a book, it's still very similar. So business law is probably one of the areas I think that European candidates can transition, or non-US candidates can transition best into, right? Criminal law is going to be hard because domestic US criminal law isn't something that, most people outside of the US have an expertise in. And quite honestly, and I've noticed this, we have very few openings for international and comparative law folks, if that's your sole focus. And the reality is I've been looking, because even though we're not hiring in that area, I was curious. And so I've been looking at the job advertisements that have come up for entry-level candidates. And it is very small compared to some of the other areas. So that is a tougher market to break into, I think, in some ways. I think a lot of law schools are pretty desperate for some good business finance type of stuff. That is a hot market. Tax, bit trickier because you'd have to teach US tax, right? And tax is very statutory, so it's a little bit less fungible. But if you have experience, getting an American tax LLM, right, that's an area where you can teach more broadly. And contract law is also an area that, because of a doctrinal class, it fits with business. It doesn't matter that you didn't go to an American law school, you can teach contract law in the United States. It's not that different from contract law elsewhere, except for this pesky little thing called consideration, which drives me crazy because I don't understand why it exists. That's off topic. All right. Only a couple more things. Yeah, I mentioned already that European legal academia has a much stronger focus on theory, which just doesn't fit super well into a lot of American law schools other than the very top tier. Practice obviously doesn't have to be at a law firm. If you have practical legal experience, postdocs are practical. If you're doing something that's substantive research related to an actual topic, working with international agencies, right? Practice depends on the area you're in, and that will all count as practice. We will look at that and say, oh yeah, this person worked for an NGO and did this kind of work as a lawyer. This person worked for the UN or some sort of think tank doing hands-on work. That's going to count as practical experience as well. Finally, I think the last thing I want to mention is that one of the things to look for as possible avenues in is to get one of the visiting assistant professorships, these VAPs as they're known, which are sort of 2-year, somewhat training you kind of into getting into academia, because that gives you a platform into American academia, and visiting, teaching fellowships, those kinds of things. There aren't a huge number of them, but there are some really good ones that are outside the ones that we always think of, like Clemenco and Bigelow and those. Like, for instance, Loyola has the Westerfield Fellows, which is a 2-year visiting assistant professorship. And it is, a really solid one that has a great pipeline of candidates. One of my colleagues did that, and that's how she was hired. So there are avenues, but you need to be creative, and you need to think about how what you do can fit into sort of this practical list of what American academia is looking at, and the ways in which American academia differ from, I think, European academia and its more theoretical focus. So that was a little long-winded, but that's what I've got to say.
Great, thank you both very much. Brannon, I don't know if you want to offer just a couple of additional comments or reflections after having heard Antonia's remarks, and then maybe we could open up the floor for discussion. There's one burning question already about potential trendiness in the American law school market that we could jump on, but I wanted to see if you had any follow-up points.
I think Antonia, both in terms of describing the sort of new normal process, and also what law schools are looking for, I completely agree. And our law schools are similar in the fact that we're both located in the Deep South, and we tend to have to do a lot of selling of the school in the region. One thing I do want to emphasize is that even though there are these rankings of law schools, I think Antonia is exactly right, that once you get outside the top 20, very, very, very small differences among law schools. And so, both in terms of, what the curriculum looks like, but then also what the students look like. You're going to be looking at schools that are very similar. And so one thing I would mention too is that, it's true that you shouldn't, you probably don't want to take a call back from a school that you have no intention of going to. But one of the things that I've noticed over the years is that if you keep an open mind about where you might end up, you may find yourself surprised about the quality of life that you can have in unexpected places. I mean, Oxford, Mississippi is a small town. It's rural, but it has a vibrant literary community, wonderful restaurants, lakes, lots of stuff. And so, people who say I could never envision myself living in Mississippi, you might be surprised. Similarly, Birmingham has a restaurant scene that's really second to none. It's a lot hillier than people think it is. And so, just when you think about if you have opportunities at places that seem like, and it's if you've made the decision to apply to U.S. law schools, then you're probably already, a little more open-minded. But just, this is a big country, and there are lots of really nice places to live. So keep an open mind.
I agree with that. And I think often what we see is the candidates with more geographical restrictions are American candidates who, whether because their family is nearby or whatever, like they want to stay in the area where their family is. If you're moving from not the US to the US, that consideration has gone out the window, right? Like all of my kids' grandparents live in Europe, and it's a pain to get there, but yeah, it's doable.
Well, I want to open up the floor for questions and comments. I would add to those last remarks, however, just the reflection that, of course, starting in Birmingham or in Oxford is also an opportunity to deepen one's competence in teaching and develop one's research. And if one is just determined, then it's also an opportunity to begin there and move laterally as well. So it's worth keeping that in mind. I want to reassure everyone that it's possible to be a European trained jurist and make a famous and impressive career. The example that's most evident for me is of Alexander Somek, a Viennese trained legal theorist and public lawyer who had a lengthy career at the University of Iowa and a very distinguished career there before he was lured back to Vienna. So let me open up the floor. Maybe I will pose the question that was percolating in the comments section, which was whether the two of you have thoughts on why American law schools may be showing less interest than a decade ago in the subjects of public, or I should just say in international or comparative law. What might be the basis of that transition, that shift?
I think that two things happened. I think number one, the financial meltdown occurred, leading to a steep decline in enrollment. And then I think we got this weird, almost instant pivot after the Carnegie report came out. There was the Carnegie Institute did a report on legal education, and when it came out, it criticized law schools for not emphasizing the training of, practice ready, and like Antonia, I hate that term, practice ready graduates. And I think that, immediately, all this, it seemed like public international law, private international law was almost a luxury. And, what they needed is to be requiring more, more courses that conveyed practical skills. The other thing that happened is we started to see declines in bar passage rates. And I think that caught a lot of law schools up short. And it seemed like, well, we shouldn't be teaching what is inevitably described as underwater, basket weaving, and make students take more courses that are going to be on the bar.
Yeah, I mean, I found it shocking that when I look, so Mississippi is part of the SEC, which is the Southeastern Conference. Like it's basically a sports grouping, but we kind of look at comparable schools. And University of Alabama is ranked considerably higher than we are. And I noticed they had almost no international law people. And so, for instance, in the entire SEC, there's really, University of Georgia has a really robust international and comparative law program. And then surprisingly, Mississippi, because we have the Air and Space Law program and one of only 2 LLMs in the country in Air and Space Law. And so we've built quite a lot of international coursework around that. But yeah, I agree with everything, that Brannon said. I mean, when I went to law school at Michigan, it was a required class to take transnational law, and they stopped making it required. And yeah.
Great. So I've got a list of questioners. Let me turn first to Pierre-Henri. I think you're coming into us from Luxembourg. Is that correct?
Yes, thank you, Russell. So let me remove my hand. Since with the Max Planck net, first, thank you very much for organizing this. It's always interesting. I might get questions, so I thought I would just join in. So I'm a Max Planck fellow at the MPI in Luxembourg. I have no intention to move, actually. I thought it would be quite interesting for me to know, in the sense that, I would have there are postdocs in Luxembourg. I will have a postdoc. So my very simple question is the MPI, the Max Planck brand, recognized in the US? Is this some kind of, let's say, plus for American law schools, that if you've gone through a Max Planck as postdoc researcher or doctoral, is this recognized in US law schools?
I think it is. I think there's a few sort of standout things that people in the American market recognize. So Max Planck researchers is one that are recognized. People with degrees from EUI is another one that's fairly recognized. Like EUI has a pretty good like brand recognition. And of course there's the like, you know, the sort of traditional big universities. Obviously the British ones are more known in the US system because of our common law links, but I think there's a recognition of, you know, at least the German and French universities that also have recognition, but Max Planck, I think, has broader than just in international law circles. I think it has name brand recognition.
That's great. Thank you.
Brannon, could you offer some reflections on that? I don't want to prejudice Antonia's reaction, but her European dalliances may have yeah.
No, I agree. Max Planck would be recognized. You know, years ago, Cumberland had a study abroad program at Heidelberg. So, you know, we currently have a study abroad program at Cambridge. And so, you know, and my faculty, one of our colleagues, our international law colleague, is from Ghana. So, you know, we have, I think, would recognize those brands, particularly Max Planck.
Great. I have Clara Rigoni from Freiburg on my list now.
Yes, thank you very much. This was a very interesting and very detailed explanation of the system. I have two short questions, if I may. And one would be, you differentiated very much between the top 10, 12 or 14 universities and the rest. Would you say that these last changes that you described about the hiring process and also about this lack of candidates, like recent lack of candidates sort of, also apply to the top universities or not? And the second question connects to what Russell was actually talking about. So what is the rate of mobility within the US after, so in tenure track positions, so basically already among faculty members? Thank you.
Yeah, so on the mobility, I think for a number of years there wasn't a lot of mobility, but I'm hearing anecdotally that right now there is a lot of mobility, and we have been seeing some more lateraling of candidates. I think while nobody was hiring anybody, nobody was moving laterally that much either. There's also been a huge uptick in the number of lateral visitors, like people going to visit for a semester or for a year from their home institution. Now, there's two types of visits at American law schools. There's what's known as a look-see visit. That's where you're explicitly invited basically as a tryout for a job. And then if they like you at the end of the semester or the year, they may make you a job offer. And then the other kind is a podium visit, where you go and you basically fill a slot. And so I know several people on look-see visits right now who are tenured, who have gone to other law schools. I'm actually going on a podium visit next semester. So I think suddenly there's a lot more mobility happening. So I think we're seeing a shift. Can I predict that this is going to continue? I don't know. I have deep concerns over financial and economic collapses, having been through a couple in my lifetime already. So is this sustainable? I don't know. If the Chinese real estate market bottoms out fully, I don't know that it is going to be sustainable because everything's interlinked. Yeah.
One thing I would say about the lateral market is I think that laterals are attractive to schools that maybe see themselves having fewer openings because you are filling a position with a known quantity or somebody with something of a record. Entry-level hires are risky. You might get somebody who looks good on paper, who interviews well, and it turns out that they're a total disaster in the classroom. And then you're sort of stuck with them because unlike in other disciplines, largely, if you get hired as a candidate, you really have to make an effort not to get tenure. You really have to work at it. And so laterals are attractive for that reason. I agree that I think laterals are upticking. I also agree that I don't know that it's sustainable. This may be just a function of, you know, people trying to fill a lot of positions very quickly and wanting to make sure that some of those positions are staffed with experienced scholar teachers who are going to be able to serve on committees really quickly as well.
And I think some of that speaks to your first part of your question, which, when we're looking at the T14, so for us, there were some candidates that we explicitly that have amazing credentials, but graduated law school about 2 years ago. And we are not in that market because we can't take that risk, because some of the more elite schools can sort of see the superstar in the making and take the risk, because tenure is much less guaranteed at the top 14 schools than it is at sort of middle rank, lower rank schools. And there's some candidates that look absolutely incredible that I think would be, gobbled up by some of the top tier schools because they have more money and they have more staffing and they can take those kinds of risks as well. And we want to make sure that even if the person is not going to be fireworks in the classroom, at least they have the practical experience so that they can be boring but sound, because at least then the students get something out of it.
Great.
Yeah, the other thing I would just say about elite hiring is that it's such a different, it's almost a completely different universe, really. And a lot of those faculties are so much larger that, yeah, they can have a couple of, or 3 or 4 duds that they absorb and either deny tenure to down the road or just harbor for years.
I wanted to mention, I know that Federica has a question, but there are a number of law faculty curated blogs that very closely track this entire industry. Brian Leiter, the Faculty Lounge, and I believe Karen's Tax Prof blogs all report on offers made laterally and very closely track all of that. That would, Clara, that would give you an empirical insight into the numbers and the character of those kinds of moves. Federica is also, I don't know if she's presently in Freiburg, but she's based at the Freiburg Institute as well.
Okay, so thank you very much for such a clear presentation of US job market. I have 3 short questions. The first one concerns job vacancies outside of FAR, because in the past I saw that there were job vacancies at some law schools that stayed open for months and months. So I was wondering whether these law schools actually consider people outside of FAR, and for how long? Because I mean, I know that the FAR process ends in September and these positions stay open even until, I don't know, winter or spring. So I was wondering whether they actually stay open beyond FAR. The second question concerns the diversity statement, and I was wondering whether you have any suggestions about how to make it strong, because I know that this is a requirement. It's a very common requirement now. And the third one concerns interdisciplinarity. I was wondering whether now being a legal interdisciplinary scholar is considered an asset. I was a lecturer at Columbia Law School in law and neuroscience, and I never actually understood whether I was viewed as a weird faculty member or whether, I mean, it was something that was actually appreciated. And I was also wondering whether there is a distinction between top law schools and other law schools in terms of welcoming interdisciplinary legal scholars. Thank you.
Excellent. Well, I will start giving, so on the vacancies staying open, this is my first time on the hiring committee. And so I don't know why these things might stay open, but I will say that we certainly do consider applications from people not in the FAR. Actually, like we have interviewed a couple lateral candidates that came through the regular job portal, because lateral candidates don't go through the FAR normally, not traditionally, but we have definitely considered them. And I mean, we go through them separately, like our weekly meetings, we go through all the candidates that have come through there, and we've been, going through them on a rolling basis. The percentage of people who are wildly unqualified and have bizarre prison sentence for embezzling money while lawyers is, slightly higher than you would have in the FAR. So there are some very unviable candidates through there, but I don't know about the staying open longer. On diversity, diversity doesn't just mean racial diversity, right? So one big area that we're interested in is, for instance, people who might be first generation college students, first generation lawyers, like, or have had experience mentoring people. So the experience of working with people to make a comfortable learning environment for people who don't necessarily have a history of higher education in their family. Any experiences, kind of, I think that's where mentoring comes in. And the idea of sort of valuing the importance of including in pedagogy some of the challenges and some of the direct engagement with diversity issues. So like I teach first year contracts as one of my classes, and I have a bit where at the beginning of the course, we look at this contract that's about basically discrimination along racial lines. It's a recent case from Atlanta. And I make sure that my students are aware that a lot of the cases we look at also have these implications of whether it's gender bias or racial bias, or, you know, when you're looking at them, or sexual orientation bias. So putting that into the pedagogy is probably where, if you don't have a whole lot of, like, you're not a first generation student or anything like that, that's where a lot of that comes in. I teach international law, so our standard overview course, and I teach it from an explicitly TWAIL perspective, third world approaches to international law. So I'm a bit more of a critical scholar, so that's sort of where my scholarship comes, so it's a little more directly engaged. But there have been a lot of workshops that American universities have been doing to bring a lot of more diversity, equity, and inclusion into the classroom. And I think that's probably a good place to talk about it. Non-interdisciplinary, it depends on the area of law. You mentioned law and neuroscience. One of the things we're looking at hiring right now are health law people, and there the interdisciplinarity is really important because you can move with the public health school and the medical school. And so I think it depends on the discipline, whether it's an asset or a liability.
Yeah, as far as the length of openings, we definitely consider outside the FAR. And in fact, we've, under pressure from our provost, we've been listing more on the university's website in a way that we had not traditionally done. I mean, all of our hiring used to be focused through the AALS, and that's changing. So, and as far as length of opening, I think we've tended to leave them open until filled, which means sometimes that they're still open. As far as diversity statements, we don't, I haven't seen a lot of them from our candidates. So I don't have much to tell you on there, other than I agree with Antonia that I think that probably, you know, the best thing you can do is sort of create the case for yourself. Like, what do you bring to the faculty? How can you contribute to the mission of the law school and the mission of the university? Finally, on interdisciplinarity, this is interesting. For the longest time, law schools, when they were making lots and lots of money for universities, tended to get away with a lot of stuff that other schools and other programs didn't do. And there was a real feeling, I think, among faculty members that law school, and deans too, that law schools were exceptional and that they shouldn't be required to play by a lot of the rules that other programs had to play by. Well, then the financial downturn came, and I swear that after that there was a whatever annual meeting that university provosts have, they started holding a session called "Screwing with Your Law School," and they sort of really brought law schools back in line. All of this is to say that law schools are looking for all sorts of ways to make nice with other units of the university these days. And anything that you can, you know, if your interests provide a pathway for collaborating with other parts of the university, I think that deans would appreciate that and encourage that.
Thanks.
May I pose just a hypothetical frame with respect to the diversity, equity, and inclusion question that Federica raised, just to get your feedback? It would be possible and maybe even tempting for foreign candidates to want to represent their foreign background and their foreign training as a quality and facet of diversifying perspectives and backgrounds. And I wanted to hear from the two of you about about the risks or viability of offering one's training in Europe, say in Western Europe, as an example of diversity in response to that mandate?
That is an excellent question. And yeah, that's not, it's not going to help you. Selling your diversity as being, I'm from Western Europe and I'm white. It's just not diversity, right? Like that's not, being from another country and culture brings a lot of benefits, but to the American law school, like that's not diversity. We're looking for the way that we can address the systemic injustices that are inherent in our legal system and that are inherent in the legal academy and the racial and gender makeup that has existed there for a long time. And that is really, I think it is very much recognizing that, we've been teaching these doctrinal classes for all these years without critically questioning what's going on. And I think, yeah, the Western European thing is not hugely going to sell on the diversity point.
The other risk that I would highlight is that, there are no more small c conservative group of people than law school faculties. And so the question with non-US faculty candidates are, the main question will be, can they teach our American students what they need to know? And so I think figuring out how to meet that objection head on and overcoming it is something that you might want to think about, because that's going to, even if somebody is, we're at law schools in the South, so our faculty is unfailingly polite. So even if they don't ask the question, why do you think that you can teach American law schools? They're going to be thinking about it. And so it's best if somebody doesn't address it to meet it, I think, in terms of either experience or in terms of classes that you can teach that would translate well.
So we've been joined this evening by Professor Nora Marquardt over at the University of Münster. And I'm really pleased to have, as an old friend and colleague, I'm pleased to have her with us this evening. Nora?
Yes, thank you, Russell, for letting me join this very, very interesting opportunity to hear a little bit more about this. And thanks for having me as an interloper here. I have three small questions, if I may. One is, how important do you think it would be for a European candidate to have an American law degree of some sort, be it an LLM or even a JD or an SJD of some sort? I don't have one. And then you've been talking, as far as I can tell, mostly about entry-level positions. And now that I do have tenure in Münster, I'm looking into things like guest professorships, sort of regular gigs at law schools, where maybe it's more interesting for them to also have somebody who's a little different from the regular faculty. So I would be very interested to hear your thoughts on that. And then finally, as I have started looking into this, I've looked at, the top law schools that I would like to teach at, obviously, to see sort of what people teach there. And I was very overwhelmed by the number of classes they had. And I thought, everything that I can think of that I think is really interesting, somebody's already doing it and they've been doing it for 20 years and at, the UN or something. So I was a little intimidated by that, and would appreciate any advice that you have on designing sort of my list of courses that law schools might find interesting. Thanks.
Yeah, so the US law degree, I'm not gonna lie, having a US LLM is really helpful. Oh yeah, here's a tip. If you apply through a school's HR website and it says JD required, put JD, like don't say you don't have one, because otherwise your HR system automatically disqualifies the candidate, even though they have a law degree and a PhD in law, just because you didn't tick that box. So just say yes. Because you all have advanced degrees, just say yes, you have a JD. It is not like that. That's a feature of HR systems. So we don't necessarily need a JD. I think the SJD as well, that's less important. I think what's interesting is now we're more interested in people with PhDs than SJDs, if that makes sense. The SJD, I don't know if that ship has sailed or whatever. LLMs are always nice, especially those if people then practice in the US, right? Those LLMs that lead you to take US bar exams. So the ones that are designed for that. But I don't think that that's absolutely necessary. On guest options, so that's not something we've done here because we haven't even had money to hire full-time professors, right? Like we've been very broke for a very long time. But I know a lot of law schools do regular visitorships, and even a lot of law schools that you wouldn't think about that might be in the middle of the country and like not, you know, not in a big city center. But in terms of putting together classes, I think there's two approaches, right? One is a lot of law schools do have needs, and a lot of the classes that are being taught may be taught by adjuncts or visitors themselves, because there's a lot of law schools with a lot of holes in them. The other thing is to sort of think about whatever your area of specialty is, and have seminars within that area that are, you know, maybe one topic focused. So I'm less well versed on that topic simply because in my time here, we haven't had any guests. We have had adjuncts that are based in Europe that teach remotely, but not people who are visiting. And now there's a whole problem coming up with that because apparently there's some tax or visa issue with having people teaching in Europe who are teaching in American law schools, but over my head.
Yeah, I think I agree, not surprisingly, with what Antonia says. The US degree would be helpful. I think it would provide reassurance to faculty members who are skeptical of hiring foreign trained law professors, but not essential, particularly if you have degrees from foreign institutions that Americans may recognize, even if they're not well versed with European higher education. As far as the entry-level visiting professors, if you wanted to try to create a regular relationship, I think that that might be really attractive to some law schools because, in part, it's cheaper. They don't have to provide you with benefits, and so it's really just an issue of salary. And so that, you know, if you were interested in that, that might be a place where you could be a little entrepreneurial, cover some courses that the law school doesn't otherwise offer at you know, something of a bargain, and maybe create a relationship where you come every other year or something like that. Might be something that would appeal to law schools. And on the courses, one thing I would note, if you're looking at the courses that are listed on a law school's website, I know as associate dean, those courses are, I mean, we've tried to purge ours from courses that haven't been taught in years, but many law schools list it's every course that has ever been taught at least once. And so there's no guarantee that those courses are being taught on the reg. And in fact, the ABA has actually gotten after law schools to try to purge those lists of courses that aren't offered with regularity. So don't, I wouldn't treat that as definitive. It may, you know, it's just, you know, those courses just stay up forever. Because I know, because students, when I was associate dean, would complain to me. They were like, why haven't we taught, you know, business bankruptcy in 12 years? And I'm like, well, we don't have anybody to teach it. So.
Yeah, so that's a really good point. Yeah, you have to look at the courses that are being offered that academic year, and that will give you a much better idea of the courses that are being offered at the institution regularly, because I have some classes I teach every other year, but there's classes on our list that I know we have never taught in the 8 years I've been here, and they're still there.
I wanted
Thanks,
to follow up with Nora's question. I might have heard it just slightly differently, and it's at least an interesting insight to note that even for the core or required 1L courses, the tradition at American law schools is that the entering class will be broken into a number of sections. And so a course in contracts, for example, will be offered maybe 2, 3, or 4 times to one entering class of law students. And that means there's space for more than one person to be teaching any of those core required classes. And in fact, it's likely that you might have 2 or 3 members of the faculty staffing each one of those first year required courses. And so it's not as though the fact that a venerable and famous researcher and scholar who is listed as teaching contracts has a monopoly on the delivery of that content in the curriculum. I'd be happy to hear from either Antonia and Brannon on a follow-up to that, but I also wanted to hear from you about the timing for the market in placing either look-see or podium visits, because the timing for those visitorships is slightly different than the timing for the hiring process that you've described. Is that correct?
Yeah, so sometimes those visiting things are posted. I think more if it's look-see, I think there's something that's posted that you can apply to. I think podium visits, often people just reach out and say, hey, can you fill a slot on our curriculum for this coming semester or this coming year? And you say, all right, sure, I can do this. But yeah, I have never applied for visitorship, so I'm not quite familiar with that. You're starting to get outside my realm of expertise, which is limited.
But it would be relevant to the work of an assistant dean who wakes up in January worried about staffing his or her curriculum.
Generally, I think that when we've discussed visitors, it would be after we had concluded our hiring and maybe not been able to make a hire for that year. I know that we had a situation in 2020, my last year as associate dean, that when I had to redo our schedule because when I learned that we were going to, the university was going to bring everybody back after we had been shut down, but at 1/3 room capacity. And I had to redo the schedule. And after one of my senior colleagues saw who taught a section of contracts, he saw that he was going to have to teach back-to-back subsections of his section. And 2 weeks before school was to start, he quit. He retired. And so I had to scramble and find a visitor. And luckily we found somebody. So it's either as needed, in that case, as desperately needed, or if there's been a failed search and we really need coverage in an area. Like Antonia, we haven't had a lot of visitors. In part of that's cultural. We have resisted visitors in courses because we tend to fall in love with our visitors and hire them when they may not be the best person for the position. That's happened in the past and has made us a little skittish about doing that.
Yeah, and I know we have a visitor this year for one of our classes who's a full year visitor, and that got posted, the advertisement for that, towards the end of spring semester last year. I think it was quite late because yeah, it's a very different market.
Great. Well, we've worn out the generosity and graciousness of our guests. If there are other questions, I'm happy to field them. And
yes,
not,
please feel free to reach out. I'll drop my email in the chat and feel free to reach out with any questions. I'm happy to answer any questions you might have. I have to run now because I have to go to a candidate's job talk. So literally the hiring committee in action during this, but I wanted to thank y'all for your time and like, it's been a pleasure speaking with everyone, and please don't hesitate to reach out to me.
Great. Thanks to both of you. Antonia, have a great interview. We wish we could attach a GoPro camera to that. Brannon, thanks as well so much for joining the call today and for extending the offer to field questions later on from the Max Planck Law researchers.
Best of luck to you all, and have a good afternoon. I appreciate being able to participate.
Great. Well, you'll hear from Max Planck Law with respect to future Max Planck Law Forward events aimed at supporting our researchers with respect to questions of job-seeking strategies and publication strategies. we'll be presenting the spectrum of our services in this area at the annual conference in October. So I look forward to seeing most of you in Berlin in a few weeks. Great. Thanks very much to all of you.